Welcome to this Killik Explains finance video. This time around, lasting powers of attorney. Short guide to absolutely vital documents. Not enough people get them in place early enough, and there are good reasons why you should. Okay, so what is an LPA, lasting power of attorney? Essentially, these are documents that need to be registered. There's a process that gives someone else, and there's a wide choice, the ability to make decisions on your behalf. Now notice, there are two types, and this is overtaken the old rules on the enduring power of attorney. It's new. So, health and welfare. That is the power to make decisions about your health and medical treatment. So, appointing somebody else to make key decisions on your behalf. Number two is the property and financial, as it's now called. Slightly different. That's all about managing your assets, dealing with bank accounts, moving property around, all that kind of stuff. And that can become vital for reasons that I'll cover in a moment. Okay, so brief summary. What would be in a health and welfare LPA? Essentially, it would be you handing over responsibility at a certain point for things like your daily routine, your medical care, whether or not you move into a home, quite sensitive decisions, and ultimately life-sustaining treatment. You've got to give careful thought to who you might appoint to make those decisions when you're no longer capable of doing so. Obviously, people don't want to think about that, but it is something we should think about earlier than we do. The other one is financial and property. This is slightly different. This is a practical, giving someone the reins, if you like, so they can manage your bank and building society accounts at the point where you're no longer able to. They can arrange payments, for example, pay bills on your behalf, collect benefits, and even sell a home where you need the proceeds for, let's say, long-term care. Now, some key issues. Who can create an LPA, a lasting power of attorney? You've got to be 18 years of age or over, whether living in the UK or not. And that's the important thing. Some people create them quite young, simply for the reason they've got assets overseas, they want them managed in the UK by somebody else, and a power of attorney, the legal and financial one, gives them the ability to do just that. With full mental capacity now, people often leave it far too late to set up powers of attorney. It's a sensitive topic, but the point is, if you're deemed no longer mentally capable of actually signing the thing and understanding it, you can't create it. You might be thinking, well, so what? Well, that creates massive headaches. Don't leave LPAs until the very last minute. Too many people do, and I understand why. Because without one, you leave behind people scrambling around, applying to the Court of Protection to be appointed your deputy. That takes time, it's hassle, it can be a year before that authority is given. And in the meantime, nothing can happen. Checks can't get signed. Bank payments can't be made. It can be an administrative nightmare. So please think about setting these things up early. How's it done? Well, a lot of this can be actually physically done online, but there are quite a few stages and key decisions to make. Number one, who is going to be your attorney and how do you want them to act? More about that coming up in a moment. Then fill in the forms. Now, there's lots of signing to be done. I won't go through all of it, but basically, as the donor, the person creating the power of attorney, letting someone else act on your behalf, you've got to get in there and sign it. The attorneys will need to sign, and there may be more than one. Those signatures need to be witnessed, and then there has to be a certificate provider. Why so much bureaucracy? Well, this is a key document, so everyone's got to be comfortable that you are happy setting this thing up. Register it with the Office of the Public Guardian, and that can take 8 to 10 weeks to complete and pay the fee. And bear in mind, what a lot of people do is they get to here or somewhere in there and they don't do this bit. Without registration, it's not valid, and that is important. You can cancel or replace an LPA at any time, so you're not absolutely bound forever to it if you want to change, for example, the attorneys, and consider getting copies certified. It's just a point that once you've got the document, the person trying to use it on your behalf will be asked for the original or certified copies before they can do anything, like, for example, access your bank account or make transfers. So do make sure you get some certified copies so you're not sending off the original in case it gets damaged or destroyed. Now, who will be your attorneys? Key decisions. There's no limit on the number of attorneys. It doesn't have to be one, could be several. Family members, for argument's sake. Somebody you trust, who knows your wishes and you think will be happy to act on your behalf. Now, it's all very well saying, yeah, I'll be your attorney when everything's going well, but actually it's a pretty stressful situation. This could be a situation where your health has deteriorated significantly. You're asking someone else to make tricky decisions on your behalf, responsible decisions, so think carefully, all right? And options would therefore include, well, people often go for a spouse, family members, but to be honest, it's a big ask, all right? So you might want to bring in a professional who's neutral, who's one step removed from the emotion, and who can take those decisions with everyone's best interests at heart, including yours, because families get into battles, move him into a home. No, he wants to stay at home and be looked after. That can be sensitive. A third-party professional can help by just sort of taking away some of those emotional pressures, if you like. You can also appoint replacement attorneys in case something happens to one of the original ones. Now, how will they make decisions? This is really important. This is not just words. If you appoint one, they'll make decisions on your behalf by themselves. But if you appoint more than one, and people often like to do that, so they want, for example, 2 children to be appointed as attorneys, or perhaps their spouse and a child, then key decision. Are you going to let them act? This is all specified in the document jointly. That means they have to agree before anything happens. You might think, well, that's good. That's a fail-safe. But it can slow things down where they disagree. So, jointly and severally means they can act together or independently. I can't tell you which is best. It varies from family to family, but that's an important decision it's worth talking through. When will the LPA activate? Now, notice this one. Property and financial can activate immediately from the point of registration, whereas the other one, the welfare one, is from the point that you, the donor, are deemed incapable of making decisions on your own behalf. Now, there's a judgment call there, and I won't go into the whys and wherefores of it, but there is an essential difference of principle in terms of when each of these things activates, and that's worth noting. Lots of ground covered, some ground not covered. Any questions, editor@killik.com, and there are other videos related to this topic at killik.com/learn.